Alright, look. Before we go 1 inch further, I need you to sit with a fact that should not be legally possible in the United States of America. A grown man walked into a federal courthouse and told a judge under oath that he was worth $4.4 million. The exact same week that Forbes magazine had a full spread on newsstands calling him a $155 million mogul. And nothing happened to him. No perjury charge. No fraud indictment. No handcuffs. Nothing. Because the man was Curtis James Jackson III, and the world calls him 50 Cent, and 50 Cent did not walk into that courtroom by accident. He walked in 15 minutes before a jury was about to set fire to his bank account, and he pulled a lever most people never even knew existed. Y'all, sit with me on this one, because this is not a story about a rapper going broke. This is a story about how the richest people in America use the poorest people's rescue tools as a personal panic button. And by the time we're done, you're going to look at bankruptcy court very, very differently. Let me pull the files, because the paper trail on this one is jaw-dropping. I read through the docket, I pulled the Hartford court filings, I traced the money from the Coca-Cola deal all the way to the Efton vodka sale, and I have to tell you, 50 Cent didn't stumble into Chapter 11. Curtis Jackson orchestrated it like a conductor. 15 minutes. That's the number I want burned into your brain. 15 minutes between the elevator ride to a punitive damages hearing in Manhattan and a bankruptcy petition landing in Connecticut. That is not desperation. That is not a broke man begging for mercy. That is a chess move, and the woman on the other side of the board never even saw it coming. Now let me walk you through the paper trail, because before you can understand what 50 Cent did in July of 2015, you have to understand how much money he actually had. Curtis Jackson grew up in South Jamaica, Queens, New York. Survived a near-fatal shooting. Rebuilt himself into one of the most commercially dominant artists hip-hop had ever seen. The music got him through the door. But the music is not what made 50 Cent rich. Not even close. October 2004. Curtis Jackson does something almost no rapper had ever done before him. He looked at a small beverage company called Glasso, the one that made vitamin water, and instead of taking the endorsement check like a normal celebrity, 50 Cent said, "Give me equity. Give me a piece of the company. Let me help you build a flavor." He co-created Formula 50. He put his name and his face on the bottle. And he took ownership. That single decision is the reason everything else in this story is even possible. Spokespersons cash a check and disappear. Owners get a phone call one morning that changes the entire trajectory of their life. That phone call came in May 2007. Coca-Cola bought Glasso for $4.1 billion in cash. The deal closed on June 7th. And Curtis Jackson's personal payout after taxes has been reported to sit somewhere between $60 million and $100 million. He has never confirmed the exact number. He signed a confidentiality clause. But that one transaction, that one afternoon of paperwork, turned 50 Cent from a platinum-selling rapper into a genuine mogul. The money started multiplying on impact. G-Unit records. G-Unit clothing. SMS audio headphones. A stake in a premium vodka label called Efton. A television production arrangement that would eventually deliver a Star's drama called Power. Forbes did the math and slapped a $155 million valuation on Curtis Jackson's name. And then there was the house. Oh, the house. In 2003, 50 Cent paid $4.1 million for a 50,000 square foot estate in Farmington, Connecticut that had previously belonged to Mike Tyson. Then Curtis Jackson poured roughly $6 million more into renovations. 21 bedrooms. Approximately 37 bathrooms. A private nightclub. A movie theater. And a monthly maintenance bill of about $72,000, with utilities alone eating another $18,000 every single month. When the money was flowing, none of it looked like a problem. When the money slowed down for even a second, that house became a stone tied to Curtis Jackson's ankle. But we'll get back to the mansion. We have to. Because the whole reason 50 Cent ended up in bankruptcy court in 2015 has almost nothing to do with the mansion, and almost nothing to do with a bad quarter. It has to do with a rap beef. A rap beef that turned into a lawsuit. A lawsuit that turned into a jury verdict. and a jury verdict that turned into a countdown clock. Pause right there because this is the pivot everyone gets wrong. Let me lay it out clean. The other rapper in this story is William Leonard Roberts II, the man the world knows as Rick Ross. In 2008 at the BET Awards, something popped off between 50 Cent and Rick Ross that turned into one of the most aggressive feuds hip-hop had ever seen. In 2009, Rick Ross released a track called Mafia Music that took direct shots at 50 Cent and referenced a woman connected to Curtis Jackson's personal life. And 50 Cent did not respond with a diss record. He didn't respond with a mixtape. He responded with something that a federal jury would eventually decide crossed every line a human being can cross. Her name is Lastonia Leviston. She is the mother of a child fathered by Rick Ross. Back in 2008, she had recorded an intimate private video with her then-boyfriend Maurice Murray, a recording she never intended to leave that relationship. Somehow, that tape wound up in the hands of Curtis Jackson. And at the height of the Ross beef in 2009, 50 Cent took that tape, edited it, and inserted himself into the footage wearing a wig, playing a character he called Pimpin' Curly. Murray's face was blurred out. Lastonia Leviston's face was not. Curtis Jackson posted the tape to his website teasus50.com and referred to Lastonia Leviston as a porn star. She had never consented to a single frame of it. She had no warning it was coming. And that is the moment the countdown clock started, because Lastonia Leviston did not disappear. She did not settle quietly. She hired a lawyer, and in 2010, she filed a lawsuit against Curtis Jackson in New York State Supreme Court in Manhattan under case number index 102449 of 2010. Invasion of privacy under New York's civil rights law. Intentional infliction of emotional distress. Her legal team, led by attorney Philip Fraden, built a case anchored on the documented psychological damage the posting had caused her, major depressive disorder, symptoms consistent with post-traumatic stress. On the stand, she looked directly at the jurors and said something that stopped the courtroom cold. She said, "This was something done to me. I didn't have a choice. I would never, ever do this to myself." And Curtis Jackson? When it was his turn on the stand, 50 Cent produced a moment that everyone in that Manhattan courtroom remembered for the rest of their lives. His version of an apology came out of his mouth as, "I'm sorry if you feel that I hurt you." And then he winked. He winked at the woman whose life he had detonated for a rap beef. And then the prosecution played a Hot 97 radio recording where Curtis Jackson himself admitted that the Rick Ross feud drove traffic to his website, which under New York law converted the tape from a personal attack into a commercial act, which made the damages number a lot bigger. July 10, 2015. Verdict day. The Manhattan jury awarded Lastonia Leviston $5 million in compensatory damages, $2.5 million for the unauthorized use of her image and likeness, and $2.5 million for emotional distress. And then the case moved into the phase that keeps every millionaire's lawyer up at night. The punitive damages phase. That's the phase where jurors are not just compensating the victim. They are punishing the defendant. They are sending a message that certain behavior has consequences. Lastonia Leviston's attorney was going to ask for $15 million in punitives. 50 Cent's attorney was going to ask for $700,000. The gap between those two numbers is the gap between a bad week and a career-defining catastrophe. The punitive hearing was scheduled for Monday, July 13, 2015, 3 days after the compensatory verdict. And on Monday, July 13, 2015, at approximately 15 minutes before that hearing was set to begin, attorneys for Curtis James Jackson III walked into the United States Bankruptcy Court for the District of Connecticut in Hartford and filed a Chapter 11 petition. 15 minutes. Not 15 days. 15 minutes. Pullman and Conley, the law firm representing Lastonia Leviston in the bankruptcy proceedings, later confirmed the timeline on the record. Their words, Mr. Jackson filed his bankruptcy petition in Hartford 15 minutes before the start of a scheduled hearing on whether he must pay our client punitive damages. That is not a coincidence. That is choreography. That is what a legal team does when it has run every scenario and calculated every angle and decided that the only way to survive the next hour is to detonate a controlled explosion first. And here is why the timing mattered so much. Under federal bankruptcy law, the exact millisecond a Chapter 11 petition lands in front of a clerk, something called the automatic stay activates. It freezes almost every legal proceeding against the filer. Creditors cannot collect. Lawsuits cannot advance. Judgments cannot be enforced. And a punitive damages hearing that was 15 minutes away from opening cannot open. Everything stops. Everything. Including a jury award that Lastonia Leviston's team had been preparing to argue should be set at $15 million. That entire number vaporized at the exact second Curtis Jackson's petition hit the docket in Hartford. The numbers on the petition told their own story. Curtis Jackson listed total debts of $32,509,549. Against that, his claimed assets came to $24,823,899. In other words, the man Forbes magazine had valued at $155 million was, according to his own sworn court paperwork, underwater by roughly $8 million. And the punitive phase that could have blown that number wide open had just been frozen solid. Now let me crack this thing open a little further, because Chapter 11 is not what most people think it is. Chapter 7 is what your uncle pictures when he hears the word bankruptcy. Chapter 7 is hand over everything. A trustee sells your stuff off. Creditors take whatever's left. You walk out with nothing. Chapter 11 is completely different. Chapter 11 is reorganization. The person filing stays in control of their assets and their income. There's actually a legal term for it. Debtor in possession. You keep your businesses running. You keep your paychecks coming in. You negotiate a repayment plan under court supervision, and you do it on your own terms. For a man with active businesses, a television career, music royalties, and half a dozen income streams still hitting his bank account monthly, that distinction meant everything. A California bankruptcy attorney named Mark Marcus put it about as bluntly as anyone in the field ever has. He said Chapter 11 filers are definitely not broke. What they are is insolvent. Insolvent means debts exceed assets on paper. Broke means the money is gone. Those are not the same conditions. And Curtis Jackson was insolvent, on paper, for exactly as long as he needed to be. 50 Cent himself was not shy about explaining it. He held press conferences comparing his situation to Walt Disney filing for bankruptcy before building the entertainment empire that still bears his name. He pointed to Donald Trump's business entities going through bankruptcy protection multiple times without anyone questioning Trump's wealth. Curtis Jackson said, "It means you're reorganizing your finances." And then he added the one sentence in this entire saga that tells you everything you need to know about his intent. He said, "But it does stop things from moving forward that you don't want moving forward." Read that sentence again. That is not a broke man. That is a man using a hammer as a scalpel. Wait, sit with this, because Lastonia Leviston was not the only person 50 Cent owed money to in July of 2015. She was just the loudest name on a very long list. The largest creditor on Curtis Jackson's bankruptcy petition was actually a headphone manufacturer called Sleek Audio. Sleek Audio had entered into a business arrangement with 50 Cent's SMS audio brand, and when that arrangement collapsed into litigation, an arbitration panel ruled against Curtis Jackson for approximately $16,181,578. By the time the bankruptcy petition landed, accumulated interest had pushed that number to roughly $18.4 million. SunTrust Bank was on the petition too, holding the mortgage on the Connecticut estate. And the Connecticut estate had become its own financial black hole. The 50,000 square foot mansion carried a listed value of $8.25 million in the bankruptcy filings, dramatically below the $18.5 million 50 Cent had listed it for back in 2007, and below the $10.9 million he had dropped to in 2010 after nobody would buy the thing. Years of price cuts. No takers. $72,000 a month in maintenance. $18,000 a month in utilities. Every single month, the Tyson mansion was quietly bleeding Curtis Jackson dry. His court-filed monthly income came in at $184,969, against monthly expenses of approximately $108,000. His vehicles, a 1966 Chevrolet Coupe, a 2010 Rolls-Royce Phantom Drophead, and a leased Bentley Mulsanne, were valued collectively at roughly $500,000. Approximately $855,000 in child support was still owed to the mother of his youngest son. 8 days after the filing, on July 21, 2015, 50 Cent's attorney James Renard stood in front of the bankruptcy judge and stated on the record that Curtis Jackson's actual net worth was approximately $4.4 million, roughly 35 times lower than the Forbes number from weeks earlier. Curtis Jackson himself walked out of that courtroom and handed the press one of the best sound bites of his career. He said, "I'm not as cool as I was last week." But here is where the whole strategy almost blew up in his face. Because 50 Cent may have understood Chapter 11 better than any celebrity in modern history, but 50 Cent also could not stop posting on Instagram. And Instagram nearly torched the entire play. While Curtis Jackson was telling a federal court that he was worth $4.4 million and could not satisfy his debts, 50 Cent was on social media flexing cash like nothing was happening. Stacks. Actual stacks of $100 bills laid out on tables. Bills arranged on a surface to spell out the word broke, apparently as a joke. Cash sitting in his refrigerator. Cash spread across his bed. A post announcing he had bought a home in Africa. Luxury cars in every other frame. That's not a coincidence either. 50 Cent knew the audience he had built was watching, and 50 Cent could not resist keeping the persona alive while his lawyers were begging judges to see him as insolvent. The people waiting to get paid noticed. Creditors filed complaints. An United States bankruptcy judge, N.M. Nevins, presiding out of Hartford, summoned Curtis Jackson into her courtroom to explain himself. Judge Nevins's language from the bench was calm and lethal at the same time. She said, "I'm concerned about allegations of non-disclosure and a lack of transparency in the case. There's a purpose of having a bankruptcy process be transparent, and part of that purpose is to inspire confidence in the process." That is a federal judge saying, quietly, "If you don't stop posting, I am going to end you." Curtis Jackson's legal team arrived with an explanation that only 50 Cent could sell with a straight face. They said the cash was prop money. Fake currency sourced from a company called RGR Props. Routine social media marketing. Consistent with the 50 Cent persona. And Curtis Jackson himself reinforced it in sworn testimony, framing his public image as performance rather than autobiography. He told the judge, "It's like music videos. They say action and you see all these fancy cars, but everything goes back to the dealership. The cars in the photos were rentals." The 65-carat ring visible in one of the shots had been borrowed from the jeweler. 50 Cent essentially argued that Instagram was theater, and the court, remarkably, allowed the argument to stand. Then in March of 2016, the story got even wilder. The United States Secret Service reportedly opened inquiries about whether the currency in Curtis Jackson's photos qualified as counterfeit. 50 Cent announced on Instagram that he was stepping away from the platform over the scrutiny, a departure that did not last a single news cycle. Meanwhile, back in New York, one of the jurors from the original Lastonia Leviston trial, a woman named Sylvia Rodriguez, went public and said the sentence that the entire country was thinking. She said, "He has it. He's 50 Cent. You know he has more than 50 Cent." But here is the part almost nobody talks about. Despite the Instagram circus, despite the Secret Service inquiry, despite a jury foreperson going on the record calling the whole thing out, the bankruptcy process kept moving. And by the end, it delivered something for nearly every party at the table. 11 days after the filing, on July 24, 2015, the court granted Lastonia Leviston's emergency motion for relief from the automatic stay. The punitive damages jury was allowed to reconvene. And that jury awarded her an additional $2 million, bringing the total verdict against Curtis Jackson to $7 million. But winning the verdict and actually collecting the verdict, those are two completely different sports. And collecting meant going through the reorganization, on the reorganization's timeline, under the reorganization's rules. Nearly a year after the filing, on July 6, 2016, Judge and Nevins approved a reorganization plan valued at approximately $23.4 million, requiring an opening payment of about $7.4 million up front and promising creditors between 74% and 92% of what they were owed. Lastonia Leviston settled for $6 million, $1 million less than the jury's verdict, but money she would actually receive rather than money she'd chase through appeals for the next decade. Sleek Audio accepted $17.5 million to close a claim that had grown from $16.2. SunTrust was addressed through the reorganization as well. And a huge chunk of the funds came from a source nobody had expected at the outset, a legal malpractice settlement. Curtis Jackson had turned around and filed his own lawsuit against his former attorneys, the firm Reed Smith and attorney Peter Raymond, alleging their negligent work had contributed to the mess he was in. That case settled, and approximately $13.65 million from it went directly into the pot that paid the creditors. 50 Cent's own lawyers admitted publicly to the Hartford Courant that a Chapter 7 liquidation would have returned creditors roughly half of what the Chapter 11 reorganization ultimately delivered. Judge Nevins wrote in her rulings that Curtis Jackson has a significant ability to generate income, which was simultaneously the reason Chapter 11 had worked for him, and the exact reason a lot of observers had never bought the insolvency claim in the first place. February 2nd, 2017. 19 months after that 15-minute filing race in Hartford, the bankruptcy received its discharge. Curtis Jackson had paid his debts. Curtis Jackson had walked out legally cleared. And Curtis Jackson had done it while never actually losing the empire. But here is where the story turns into something else entirely, because the discharge was not the ending. The discharge was the starting line. In 2017, 50 Cent reportedly sold his remaining stake in Vodka, and Curtis Jackson announced the deal on Instagram with all the restraint of a man who had never heard of a courtroom. He posted, "I got the bag. Effin' vodka. Can you say $60 million?" The brand's parent company disputed whether he had fully exited the arrangement, but even a partial sale at that reported figure would have covered everything Curtis Jackson had paid out through the bankruptcy, and then some. The Tyson mansion in Connecticut finally sold in 2019 to a buyer who paid $2.9 million for it. Less than 50 Cent had originally paid for the property. A fraction of the $18.5 million he had once asked for. But the mansion was off his books, and the bleeding stopped. Power on Stars expanded into a multi-series franchise. In 2018, Curtis Jackson signed a 4-year overall deal with the network reportedly worth an estimated $150 million. A G-Unit Final Lap tour reportedly grossed over $100 million in ticket revenue. The man who had once sat in a Hartford federal courtroom and told the judge his net worth was $4.4 million had, by any measure you want to use, rebuilt everything he had ever supposedly lost. And a whole lot more. So here's where the whole thing lands, and this is the part that should sit uncomfortably with every single one of us. Bankruptcy protection in the United States was designed for a very specific and very human purpose. It exists to give people and businesses buried under debt a fair path to resolution. It exists because the country decided long ago that economic rehabilitation is worth more to society than simple punishment. It exists to keep a family from losing everything when the medical bill, or the divorce, or the recession lands harder than they can absorb. That is what the tool was built for. But the same tool, in the hands of the right lawyers, becomes something completely different. It becomes a stopwatch pointed at a woman's dignity. It becomes a negotiating platform. It becomes a legal weapon that gets used with surgical precision 15 minutes before a jury can finish penalizing you. The automatic stay does not ask you why you are filing. Desperation and strategy produce the exact same legal result. The clock stops either way. And what Curtis Jackson demonstrated in Hartford, with the timing of a heist and the calm of a chess grandmaster, is that Chapter 11 can function as a negotiating table as easily as it can function as a rescue line. Filing forced every single creditor into the same court, on the same timeline, under the same judge. Lastonia Leviston, who had won a jury verdict and stood minutes away from a punitive damages hearing that could have produced a number several times larger, found herself instead in a Connecticut bankruptcy courtroom she had never planned to visit. She received $6 million. Whether that constitutes justice, genuine, complete, real justice, depends entirely on whose seat you are sitting in when you answer the question. Her legal team did secure something that mattered. They secured a court-supervised, documented, enforceable repayment. Real money. Not a paper verdict that might have taken years of appeals to collect a dime from. And as Curtis Jackson's own attorneys openly acknowledged, Chapter 7 liquidation would have returned creditors roughly half of what the reorganization actually delivered. That is a fact, and it complicates the moral scoreboard in ways nobody wants to talk about. When the case closed, Lastonia Leviston released a statement that deserves to be quoted in full. She said, "I am extremely proud and thankful that my team helped me find the courage to stand up to a man who took advantage of and humiliated me in front of the entire world. I've been served justice by the courts and vindicated by God." Read that carefully. Vindicated by God. Because the courts, in her own words, gave her justice. And God gave her something the courts could not, the vindication that comes from being believed, publicly, on a stage this large. This is a story about money, but the money is really just the vehicle. What Curtis James Jackson III actually demonstrated is how power operates in America, who holds it, how they use it, and how tools built to protect ordinary people can be turned by those with the resources and the legal firepower to do so. 15 minutes before a punitive damages hearing. Prop cash on Instagram while creditors waited. A $7 million verdict settled for $6. Out of bankruptcy in under 2 years. Then a reported $60 million vodka sale shortly after. Not one step of it was illegal. The woman who was wronged received a payment. The man who wronged her remained wealthy. And the system worked exactly as it was designed to work, for the person who understood it best. And that is the piece that should haunt you as you close this tab. Because the law does not reward the victim. The law rewards the person who understood the law first. Curtis Jackson understood it. His lawyers understood it. 15 minutes was all it took to move a hearing from Manhattan to Hartford, from a jury of 12 strangers to a judge in a different state, from a public flogging to a private negotiation. Lastonia Leviston walked into her fight expecting a battle. She walked out having been rerouted into a completely different courtroom, under a completely different set of rules, playing a game she had never signed up for. And she still won something. That is a testament to her lawyers and to her endurance. But it is not the victory the jury had almost given her. So here is the question I want to leave you sitting with. If Chapter 11 bankruptcy, the single most powerful reorganization tool the American legal system offers, can be deployed as a scheduled defensive weapon by a man whose Instagram account is simultaneously flexing stacks of $100 bills, then who exactly is the tool protecting? Is it protecting the family that lost the job? Or is it protecting the celebrity who lost a verdict? And if the answer, on paper, is both, then what does that say about the country the courts are actually serving? That's the story. That's the whole story. That's the story. Curtis Jackson filed 15 minutes early, walked out 19 months later, and turned a moment that should have cost him everything into a footnote on the way to a bigger deal. Lastonia Leviston walked away with $6 million and a statement that will outlive every headline about it. And bankruptcy court in Hartford, Connecticut, on July 13, 2015, quietly wrote one of the most consequential celebrity playbooks of the modern era. A playbook other people with lawyers and empires are still studying today. If this made you look at the word bankruptcy differently, if it made you think about who the courts actually protect when the person on trial is famous enough, drop me a comment. Tell me whose seat you were sitting in as you listened to this. Lastonia's. Curtis's. The judges. The juror who spoke up. I read every one of them. And if you want the next story like this one, because there are plenty, and most of them are worse, you already know what to do. Talk to y'all very soon. Okay, bye.